All clear. Well, thank you very much, Raphael, for your interesting input and presentation. We're now moving to the third topic of the day, namely moral rights. Study questions number 282, which will be presented by Reinhard Oertli. So Reinhard, the floor is yours. Thank you.
Good afternoon, or good evening rather, dear friends. So the moment that I fear most in these online presentations is the moment when it comes to sharing the screen. And then immediately afterwards comes the fearful moment when I recognized that some experts here on copyright law are within the panel and may sort of put me on the grill with some of the things I'm going to say, but I'm looking forward to that too. But now the cliff of screen sharing. What do you see now?
It looks good to me.
Does it look good to you? Very good. So moral rights in copyright. That means copyright is already sort of the poor family member of IP right. And within, this poor subfamily of IP right, there is a particularly poor branch of the family, sort of un vrai enfant délaissé, a waif. And that is the moral rights in copyright. And not only is it neglected, but it also a sort of perceived controversy between legal and copyright systems. The Anglo-Saxon copyright system starts from the copy, the right to make copies and sell copies, and it is basically an economically driven right. And the copyright in the French or German tradition is basically a right that stems from the personality, that is an outflow of the personality of the author. That's what Kohler, in the 1920s or so, wrote about, and that what is still a central point of French copyright law. So for the French, the moral rights are really at the center of the copyright, and for the Anglo-Saxons, they are at the very fringe. That being said, moral rights do exist also in Anglo-Saxon jurisdictions, not in America, not on the federal level, but on the state level. So some states have very far-reaching moral rights statutes. For example, New York or the state of Illinois have very far-reaching rights. So the discrepancy then, if you go into the details, is not as strong and fundamental as many think they are. So the Swiss group set up a delegation to work on the Swiss resolution, comprised of Mark Wohlschläger of Isler Predazzini, the head of the group, Fabian Wicker of Einmann-Zimmerli, Hugh Reeves of Walderwies, and myself. And working on these study questions is a delight. I love it, and I can only recommend it to any member of AIPPI. It's a real perk. It's a real benefit of being able to work on these study questions and to share ideas and concepts and to work with specialists in their field and novices, and both is a pleasure. So that's how these are the different topics I'm going to address here. And I do not sort of so clearly distinguish between what the Swiss group said and what a resolution of AIPPI at the World Congress in San Francisco says, unless there is a discrepancy, unless there is something that really falls apart. So are really moral rights rather a part of the right to protect the personality of the author, or are they rather part of copyright and inseparable from copyright? That is one of the sort of fundamental issues that drives the discussion. Then here you see a list of categories of moral rights, or types of moral rights that Swiss law knows. The Erstveröffentlichungsrecht, the right of first disclosure, the right to claim authorship. That means the right to say I am the author. There is also a little brother to this right. That is the right to disclaim false attributions. So the right to say I am not the author of that work. I did not write it. The right of integrity, the Entstellungsschutz. You remember that has two prongs. The first prong is the copyright owner can permit modifications of the work. And the second prong is, even if the author has permitted modifications of the work, he can still object to modifications that affect his honor and his reputation. Now, the protection against destruction, you remember, this is the right, if there is only one copy and the owner is going to smash it, you can either take it back or make at least a photo of it. So you remember that the English Parliament had a painting made of Churchill, and when he didn't particularly like it, when his widow particularly hated it, the painting, and when she died, it was always hidden in his household, and when he died, his widow destroyed the painting. And there is in fact no trace of it. There is no photo or no reliable trace of how this painting looked like. It's gone. That is the right of destruction. No other jurisdiction has it. And when we put up in the plenary discussion, the motion to insert this right of this against destruction into the list of moral rights, nobody really understood what the Swiss were talking about. We were not particularly successful on that. Then there are the general limitations of moral rights, the general limitations, sorry for writing here exceptions, that is a mistake. These are not exceptions, these are limitations. I insist on that use of the language. So die Schranken, these are Schranken, nicht Ausnahmen of copyright law. There are some specific limitations that address moral rights. That is the right to make parodies. A parody is by definition a violation of the moral right of the original author. Otherwise, it's no good parody, and the law still allows you to do it. Then there are limitations that ought to apply to specific categories of works. We come back to that. That has been that is more the approach. That was more the approach of AIPPI worldwide. That they don't like sort of abstract concepts. They like specific categories, and then you name them, and then you know what you're talking about. Then who has the right? Who carries the right? So there is an unanimous assumption that only the author as a national person can be the real owner, the first owner, the initial owner of moral rights, and not a legal entity. There is no made for hire. You know, in Swiss law, there is always a physical person, eine natürliche Person, who is the author, who has the moral rights. Now, I understand normal copyright specialists do not read Article 393 of the Swiss Code of Obligations. It's a matter of pride not to read that article, because the article says, you know, if you work on a Sammelwerk, you know, on a compounded work, it's the editor, the person who set up the composition, who has the copyright in the work, and the contributors of the individual parts only have a right to remuneration. They do not have any moral rights. That is an interesting strain in copyright, an interesting current, you know, that brings the Swiss law back into proximity of the works made for hire doctrine. Copyright is transferable by contract, by assignment, and inheritable, of course. We know that. Now, the moral rights. The moral rights are not transferable by contract, by assignment. But they are transferable by succession. And by way of succession, the author can, of course, make a legal entity his or her heir. You understand? So by way of succession, a legal entity can become the owner of the moral rights, but not by any other means. Now, this inalienability, you know, you cannot give away your moral rights. Should that be? I mean, what's with the freedom of contract? You know, where is our freedom of contract that the Swiss hold so highly and cherish? If the ghostwriter contract says, I write the work and I give you the right to claim authorship, no, and I sort of waive my moral right to claim authorship. The sort of learned people to know cannot make anything out of that, and sort of grope in the dark. You know, my personal position is that of course this is a valid contract, but of course when you have sort of made a ghostwriting contract for your last 10 books, you know, and you sort of have given away your life production as an author, you can claim authorship, but then you lose the remuneration and have to pay back the remuneration and have even to pay contractual penalty. Then the nature of the work that was discussed in San Francisco. What's with the moral rights of somebody who has contributed to an audiovisual work, you know, a movie, but in a very limited part? Can he then sort of exercise his moral right and say that he does no longer want this film to be distributed because he does no longer like it, but he contributed only a very minor part? In my understanding, it's not appropriate to single out audiovisual works, but to require a balancing of interests, you know. How much is the moral right affected and how much is the interest of the other rights holders and the public to have the work distributed nonetheless?
Reinhard, Excuse me, let me just jump in. I'd like to keep to the schedule. So if you have like 2 or 3 more minutes to finish your presentation, that would be perfect.
Yes.
Thank you very much.
Then that is the duration of the moral rights. In our understanding, the moral rights have the same duration as copyright as a whole. In many Anglo-Saxon jurisdictions, the duration is shorter. In French law, if I think that's still the French law, yeah, it's perennial. You know, it even when the remuneration rights end, the moral rights still apply. So this was a hotly debated issue in San Francisco. In particular, the Australian group, you know, made a prominent point out of this. But also some European jurisdictions were willing to compromise on this. But the end result was the easy solution, you know, moral rights last as long as copyright. I'm not sure that is totally appropriate. I rather think there should be a balancing of interests, and the balancing of interests over time require that the scope of moral rights are reduced, go down. Then of the poor sibling and the poor sibling, you know, the moral rights in copyright, there is another poor sibling, you know, that are the moral rights in related rights, you know, in particular, the moral rights of performers. It was absolutely impossible to find any sort of compromise or common ground in San Francisco, so this was deleted from the discussion. There is some interest to change even Swiss law, you know, particularly this sort of double standard against changes to a work that is not very commonly known in other countries outside of Germany and Switzerland, and that is sort of something we would like to change. And the different scope of moral rights depending on the category of works, yes, but then when it comes to discussing the categories, you know, it's easy to say that the moral rights in the computer program cannot be the same as the ones in a love poem or in a novel, but then it quickly ends there, you know, the discussion. So this is my presentation, and I'm glad to answer your questions.
Thank you very much, Reinhard, for wrapping up promptly. So the floor is open to any questions or comments from the audience.
Yes, I have a question, Reinhard, regarding the assignment of copyrights, and you mentioned on the last slide on your presentation regarding software. In practice, we have the problem.
There is no screen sharing now. Yeah.
No, it's fine. It's fine. I have it in my mind. Regarding the assignment of copyrights in connections with software. So when you have a transaction, you know, under Swiss law, it is possible to assign a software. The Germans consider every bit of software a Mona Lisa or a symphony. So which is, you can give only exclusive rights, but not assign the rights because of the moral rights attached to it. Are there any harmonizations?
Now, well, that's a thorny issue. The Germans consider the copyright inalienable.
Yes, exactly.
Copyright is inalienable because copyright for them it's inseparable from the moral rights.
Exactly.
The Austrians are a little bit more liberal on that, you know, and the Swiss misunderstand. You know, the Germans say, yes, I can give you Nutzungsrechte. That's all I can give you, but that's all you are interesting, because what I retain are the moral rights and you give you all the Nutzungsrechte. And the Swiss say, no, I don't want Nutzungsrechte. I want the copyright. You know?
Exactly.
So we don't understand each other.
Okay, but that was not addressed in. It would go too far. I mean, if you say it correctly.
Nobody, absolutely nobody outside of Germany, not even the Austrians, really understand the German concept.
Okay, but it was not addressed.
It was not addressed.
Okay,
the Germans did not bring it up.
Okay.
Not even the Austrians, who have the same wording in their own statute, understand the German interpretation of it.
So we have to live with it. Thank you.
Well, they have to live with it.
Okay.
We don't. We can assign copyright. We can split it up. In copyright for us is a bundle of rights. It's a basket. It's a basket that we can take individual apples out of the basket.
Exactly.
Thank you very much. And now, last